Good morning, everyone. Welcome to this Radcliffe Chambers Junior Programme Property Edition. My name is Amber Turner. I'm joined today by two of my lovely colleagues from our property team, Natalie Pratt and Olivia Wilson. If you've attended one of our junior programme events before, then you'll know that generally there would be two short talks on different topics within the same practice area. But Natalie, Olivia, and I have decided to do something slightly different and tackle one bigger topic altogether. And we chose a topic that we've all had plenty of recent experience in, which is forfeiture. We know that it can be a tricky topic and a tricky situation for both freeholders and leaseholders. So, what we'll try to do today is unpack some of the tricky elements together. Unfortunately, we won't be able to take questions today, but if there is anything you'd like to ask or follow up on, then you'll find our email addresses either on the slides, which will be sent out to you, or you can also find them on the Chambers website. And so without further ado, I will hand over to Natalie to get us started.
Good morning, everybody. As Amber says, my name's Natalie. I'm doing more of an introductory element to the talk, and then Amber is going to take over. No, she's not. Olivia's going to take over and talk to you about waiver, and then Amber will come along behind and do something on relief from forfeiture. So I think arguably I have the easiest job of the three. So I'm broadly doing 5 things today. So I'm going to look at what is forfeiture, when is forfeiture available, how you can affect forfeiture, are there any restrictions on the right to forfeit, and a more practical question of whether a landlord should, in fact, forfeit. Just because the right has arisen doesn't mean that you should, in fact, execute it and go for it. So taking the first question then of what is forfeiture? So forfeiture is a landlord's right to determine the lease before the end of the term. And ordinarily that will happen where the tenant is in breach of their obligations under the lease, or on the occurrence of some specified event or an event that is specified in the lease. So one that you might often come across is an event of insolvency, might give rise to the right to forfeit. Now, you've probably seen this referred to as re-entry as well, and the two terms are used interchangeably. So forfeiture and re-entry, or a forfeiture clause and a re-entry clause, essentially mean the same thing. And as I said, forfeiture will terminate the lease, but it won't just terminate the lease, it will terminate any derivative interests as well. So if you've got a subtenancy or a submortgage or a mortgage, those interests will terminate on the termination of the tenancy on forfeiture as well. And as Amber may speak to you in a moment about, those parties, so your subtenant or your mortgagee, they are entitled to apply for relief from forfeiture as well. They are parties to whom that right applies. Now, forfeiture is not compulsory. Just because you have a breach of a lease obligation does not mean that a landlord has to elect to forfeit. It is just that, it's an election. And the landlord may actually elect to treat the lease as continuing. But crucially, you are bound by your election. They are mutually exclusive. And in a moment, Olivia is going to speak to you about waiver, because in some circumstances, you may find that a landlord is deemed to have treated a lease as coming to an end rather than intentionally having done that. So when is forfeiture available then? So it probably helps to break it down into 3 categories as to when forfeiture is available. So the 2 headline options are a breach of covenant or a breach of a condition in the lease. And then a breach of covenant you should break down into 2 further subcategories. So the covenant to pay rent, and basically then any other covenant. So the typical ones you see, such as your repairing covenants or your covenants against alienation. Taking a breach of condition first, so taking them out of order because it's perhaps slightly easier to cover. A condition is exactly as we understand it in contract law. So it's a term that goes to the heart of the transaction, and it's always a question of construction. And in this case, it'd be construction of the lease. It may be that if your lease has been drafted in a very particular way, that actually the obligation to pay rent is a condition rather than a covenant. So don't always just assume that you're looking at a covenant to pay rent. It may in fact be a condition. It will be a question of construction. And if it's a question of construction and it turns out to be a condition, these are the rules that will apply. And it's important to be able to classify whether you're dealing with a breach of covenant or condition, because if it's a condition, crucially, you do not need an express re-entry clause in the lease. There is an implied right to forfeit. It's always best practice to include one. So if you are if you're dealing with the transactional side of things, if you're helping draft a lease, it's always worth including an express re-entry clause that covers conditions as well. It just takes away any ambiguity as to whether the right has arisen or not. So breaches of covenants then, perhaps a little bit more tricky, have more rules that govern them. Here you do need an express re-entry clause. There is no implied right to forfeit for a breach of covenant. So you really must have an express forfeiture clause in the lease if you want to forfeit for a breach of covenant. And you really need to pay attention to the drafting of that covenant, of the lease as well, and the forfeiture clause, because if it has any required preliminary steps, or if it has any conditions that need to be met before the forfeiture can be exercised, you really must be meeting those conditions, because otherwise you very much run the risk of an unlawful forfeiture occurring or a wrongful forfeiture occurring. And then the tenant has many options to remedies there. So you might find yourself on the wrong end of a claim for declaratory relief or injunctive relief or damages. Sorts of conditions that you might come across that you might need to be aware of and be alive to. It may be that certain demands need to be served before the right to forfeit can be exercised. Or it may be that there are specific time periods that need to be observed. So always keep an eye on the drafting of the lease and make sure that you are absolutely complying with anything that's there in that clause. So if it's a breach of covenant other than the payment of rent, you must be serving your Section 146 notice to alert the tenant to the fact that there is a breach and forfeiture is on the cards. You've probably all come across Section 146 Law Property Act. There are three conditions, or there are three points that your forfeiture notice under Section 146 must meet. So the notice must, unsurprisingly, specify the breach. If it's capable of remedy, then it must require the tenant to remedy the breach, and you must give them a reasonable time by which to do that. And thirdly, the notice can also require the tenant to pay monetary compensation for the breach. Now,
I have a question, Nat. Sorry to
yeah,
interrupt. What if the breach of covenant can't be remedied? What should you include in the Section 146 notice then?
yes. So if it's not capable of being remedied, you still have to give the tenant a short period of time in which they can consider their options and specifically whether they want to bring an immediate claim or immediate application for relief from forfeiture. The case law, there is case law that says that 2 days is too short, 5 days is sufficient, and therefore 14 days in other cases has also been sufficient. It'll be very much a case of context and circumstance, but it's not a case that you can then just proceed to immediately forfeit. You do still have to give a very short period of time for the tenant to assess their options and what they're going to do in response. And actually, on that point of what is a reasonable time, how much time period you have to give, when you're drafting the Section 146 notice, if you're involved in the drafting, be very careful about stating what you think a reasonable time is. So within the notice itself, I would only ever refer to a reasonable time. I wouldn't pin your colours to the mast, and I wouldn't state what a reasonable time is. If you want to do that, you're best placed doing that in the cover letter, because you run the risk that if a tenant were to challenge your Section 146 notice and say, actually, you've given me an unreasonable time, and the court were to agree with that, your notice becomes invalid. So if you say you've got 6 weeks to remedy this disrepair, and a court says, no, we think 12 weeks was the reasonable time, it's game over for that Section 146 notice and it's invalid. So move away, if you are, I would say, from stating a time in the Section 146 notice. And if you really want to give an indication, give it in a covering letter. And actually, on that subject of disrepair, make sure you're aware of the Leasehold Property Repairs Act 1938. So the 1938 Act will apply to leases that were granted for 7 years or more, and where they have 3 or at least 3 years left to run. And the 1938 Act only applies to repairing covenants and repairing obligations. So if you have a composite covenant that has various overlapping elements. So maybe, as you might often see, it has a repairing element and a cleaning element, for example. The Act will only apply to the repairing element. Now, if you are alleging a breach of a repairing obligation, Section 1, subsection 4 of the 1938 Act requires the Section 146 notice to state that the tenant has rights under the 1938 Act. And if it doesn't make that statement, your Section 146 notice is going to be, again, invalid. So you have to alert the tenant in the Section 146 notice that they can claim the benefit of the 1938 Act if they want to. And the benefit of the 1938 Act that the tenant can claim is that within 28 days of service of your Section 146 notice, they can serve on you a counter notice, or they can serve on the landlord a counter notice. And it really doesn't have to say very much. It literally just has to say, we claim the benefit of the Act. And the benefit is that then the landlord is precluded from any proceedings, action, or otherwise. That's being the phrase in the statute. They're precluded from those things. They're precluded from doing those things and forfeiting and re-entering unless they have the court's permission. So they need to make an application for the court's permission before they bring any proceedings or indeed go on to peaceably re-enter the property.
What circumstances would be required for the court to give permission for that?
Yeah, so it is a separate application. They still have to prove on the balance of probabilities that permission should be granted. And they need to prove one of the statutory factors at Section 1, subsection 5. And so, I mean, they're not particularly shocking. It's as you probably would imagine them to be. So you need to show that you're trying to prevent injury to the reversion. It's necessary, or the remedy is necessary to give effect to any enactment. You'd need to show possibly that the immediate remedy of the breach is going to be at a very small cost compared to remedying it much later on, so postponing the remedy. And then there's your typical catch-all provision where if there are special circumstances which the court considers just and equitable. So there are various statutory factors. Only one needs to be proven, and it's on the balance of probabilities. So why is the rent covenant different? The headline point here, as you probably all already know, if you're looking to forfeit for a breach of the rent or the covenant to pay rent, you don't need to serve a Section 146 notice, and that's catered for in Section 146, subsection 11. So how do you go about forfeiting? So you've done all your necessaries, you've served a Section 146 notice if you need to, or you've got a breach of a condition, or you've got a breach of the rent covenant, and you're up to the stage of, well, how do we go about doing this? You've got two options. You can either go for peaceable re-entry of the property, or you can commence proceedings under Part 55 of the Civil Procedure Rules, and it's a claim for possession under Part 55. So when it comes to re-entry of the property, when we say peaceable re-entry, that has to be peaceable to the person rather than peaceable to the property. And it needs to take place or take way by some sort of unequivocal act.
I was going to ask you what sort of examples of
Jump the gun, Amber. Jump the gun. So examples of unequivocal acts. You would ordinarily expect some sort of physical re-entry. Usually that would be by doing something like changing the locks or securing the property in such a way that it excludes your former tenant. But if a landlord's only excluding or securing the property against third parties, that may not count. So, for example, you've got a tenant who's absconded and left the property insecure, so they've just left the door flapping open, and the landlord goes and secures the door. That may not count as peaceable re-entry, because what you really need to be doing as a landlord is excluding your former tenant who you've elected to forfeit against. And depending on the circumstances as well, you may have constructive re-entry. So, for example, if you let a third party into occupation and treat them as a tenant, that may amount to peaceable re-entry. Or if you start accepting a subtenant's rent, that may amount to peaceable re-entry constructively, but only if you're treating them now as if they're your tenant and it's a new relationship that's arisen between you and what was the former subtenant. If what you're actually doing is acknowledging and accepting the subtenancy, that's completely inconsistent with forfeiture, because you're then acknowledging that intermediate or head lease. When it comes to proceedings, the absolute key date and your unequivocal act is service of the proceedings, not issue, but service. That's the point at which you have elected to forfeit. And actually, the date of service is incredibly important as well, because that triggers what we call the twilight period. And the twilight period is important for two reasons. Firstly, from the twilight period or during the twilight period onwards, you're only then claiming mean profits. You're not claiming rent if you're making a monetary claim. And also, and perhaps maybe more importantly, you can't make a claim as a landlord for a fresh breach of covenant unless there's also tortious liability that arises from that breach. And that is the case because you as a landlord have elected to forfeit the lease. You're treating the lease as having come to an end, and therefore all the obligations of the lease are being treated by you as having come to an end. So you can only really claim for fresh breaches in the twilight period if they also give rise to some other liability and tort as well. So which one do you choose? When do you do peaceable re-entry? When do you go for proceedings? There are some statutory controls on this. So the Protection from Eviction Act 1977, Section 2, a landlord has to seek a court order where the premises are let as a dwelling. That's the big restriction. So pretty much always, if you're dealing with a residential property, you're going to be going off and issuing Part 55 proceedings and seeking a possession order. You're not going to be doing a peaceable re-entry. There are some other statutory controls as well. So put on the slide there, the Criminal Law Act 1977, Section 6. So that prohibits the use or the threatened use of violence when taking control of a property. That applies equally to residential or commercial. Realistically, you're probably only doing peaceable re-entry in the clearest cut of cases when you've got a commercial premises that is perhaps unoccupied, or certainly unoccupied at the time that possession is in fact taken and re-entry is in fact exercised. So that's why you get your early morning raids on the commercial premises to change the locks. There's a couple of other controls as well, or restrictions on when you forfeit. So I've just put two on the slide there. So if you're dealing with an insolvency situation, just be alive to the fact that there are some restrictions if you're dealing with an insolvency. So depending on which insolvency process is being pursued, it may be that you cannot forfeit by way of proceedings unless you have the permission or the consent of the insolvency practitioner who's been appointed, or if you've got the permission of the court. And the other key restriction that I think probably everyone is aware of, the Housing Act 1996, Section 81, subsection 1, if you're looking to forfeit for non-payment of service charge or non-payment of administration charges, you can't just crack on and do that. You either need a court judgment saying that those sums are in fact due and owing and outstanding, or you need an admission from the tenant. You may come across some situations where you have a mixed use premises. If you've got a mixed use premises, you are bound by the Protection from Eviction Act and you will need to have a court order. So just be alive to that. And then that takes me to the last question of, should you forfeit? Just because you can doesn't mean that you should. The first bullet point on the slide probably doesn't really belong there, but it's one that I think is really important. Just be really aware of wrongful forfeiture, because you could suddenly find yourself on the wrong end of the claim as the landlord. If you can suddenly find yourself facing a claim for damages, injunctive relief, or declaratory relief. The key thing to think about is, what are the commercial considerations? If you've got a falling market or a stale market and it's unlikely that you're going to get a new tenant once you've taken possession, you might take a commercial view that actually it's worth keeping your current tenant in there, especially if their hardship or that breakdown in the relationship is temporary and there's a chance that they may come back to be a good tenant. And also, frankly, just having someone in the property can be beneficial when you think that an unoccupied property is then at risk of trespassers and squatters, for example, especially if you've got a big commercial premises. So there are other considerations like that need to come into play. You might also want to think about, how likely is it that if relief is going to be granted? Because if you're in a situation where it's very, very likely that relief is going to be granted, whilst that may not necessarily impact on your decision whether you do forfeit or not in the first instance, it will certainly impact on how quickly or how inclined you are to settle and the sort of deal that you might do by way of settlement. And also, or lastly, other remedies are available. So if you are forfeiting for non-payment of sums that are due under the lease, you might think instead about doing a statutory demand to try and recover the sums. You might try and have recourse to any guarantors under the lease. Or if you've got a rent deposit, you might think about whether you can dip into that to meet any sums that are due and owing. And if you're forfeiting for a breach of covenant, you might think about actually is the better way here Part 7 proceedings and seeking damages or injunctive relief for that breach. So that is me. That's my email address if you have any questions later on. The QR code is there. If you don't get to scan it now, that's fine. It will come round in the slides. You can give me some feedback on whether it works or not, because I'm not entirely sure.
Thank you, Natalie, for giving that overview on when the right arises. And as Natalie has suggested, a landlord doesn't have to forfeit if the right to forfeit has arisen. And also, waiver can occur where you're essentially treating the lease as continued to exist, and that is waiving the right. It is based on the doctrine of election, so choosing between two mutually exclusive rights, as you can see on the slide, essentially two paths to go down. Do you forfeit or do you treat the lease as continuing to exist? What we do see in our practices sometimes is a landlord may not have realised that they have waived the right. Sometimes they do so accidentally. So it's an area of forfeiture which requires some knowledge, which is why we thought we would cover it today. You can see a quote from the case Matthews and Smallwood, which is often used to define waiver. So it's a waiver of a right of re-entry can only occur where the lessor, with knowledge of the facts upon which his right to re-enter arises, does some unequivocal act recognising the continued existence of the lease. So there are three ingredients. Firstly, the landlord's knowledge. Secondly, an unequivocal recognition of the continued existence of the lease. And thirdly, communication. So I'm going to run through those now. The knowledge required is of the basic facts, which in law amount to a breach of covenant, not knowledge that they have waived the right. That is why we can get people coming to us who may have inadvertently waived their right, despite knowledge being a requirement. So there's no requirement that they intended to waive their rights. There's difference between knowledge and intention. Irrespective of intention, if the lease is treated as continuing to exist, that is a waiver. Knowledge can be imputed onto the landlord. So there's case law where it's a solicitor, a porter, an employee, and also agents, although it depends sort of how limited the authority of the agent is. So it's sort of a case-by-case basis. Where the landlord suspects on reasonable grounds that the tenant has committed a breach of covenant, but takes no steps to establish the truth or falsity of the suspicion, that has also been taken to be sufficient knowledge for the purposes of waiver. The burden of proving sufficient knowledge lies actually with the tenant. And so those 5 boxes on the slide are sort of the headliners for knowledge. It really comes down to knowledge of the basic facts, which in law amount to a breach of covenant. So moving to the second requirement, which is a little bit more difficult, we need an unequivocal act. So a positive act needs to be done to recognise the continuance of the lease. So for the avoidance of doubt, serving a section 146, as Natalie stated, sometimes needs to occur. That doesn't count as an act. But for example, notice to quit can amount to a waiver.
I have a question, Liv.
Yeah, go for it.
Can we not just in our leases start drafting like neat no waiver clauses? Would that not get us out of all these bear traps?
Wouldn't that be lovely?
Wouldn't
Well,
it, John?
I suppose we'd have less work if that happened.
Well, yeah, okay, yeah, don't tell them that.
Okay, no. Well, lucky for us, it's not that simple anyway. These clauses sometimes you see are actually just ineffective, which does make sense when you think about it conceptually, because how can the landlord claim that the lease is at an end while also relying on a particular clause in the lease to prevent the waiver from happening? So unfortunately, it's not that simple. A classic example of waiver that we probably encounter most regularly is acceptance of rent, which has accrued after the right to forfeit has arisen. So similarly, stating that the rent is accepted without prejudice to the right to forfeit, or for example, that they're accepting the rent under protest, doesn't work. It's not good enough. It's still a waiver. It's not a waiver if the rent that accrued before the event that gave rise to the right to forfeit. So timing can sometimes be important, but it's really something to give good thought to. For continuing breaches like disrepair, where rent is accepting during the currency of a Section 146 notice, that's fine, because the right to forfeit actually hasn't arisen until the notice expires. But that situation is unlikely to be the case for things like once and for all breaches that are irremediable, such as subletting. So a landlord's agent accepting rent is also sufficient to waive, even if they've been instructed not to receive it. And similarly, acceptance of rent because of some sort of clerical error will also, in most cases, amount to a waiver. If rent has been paid into a landlord's bank account, potentially, even if a sort of rent stop has been attempted, it won't necessarily be taken as acceptance of rent if the landlord rejects the payment and repays it quickly, if the circumstances permit. So, for example, trying to send it back by bank transfer to the tenant, that's sort of a damage control step that can be taken. Obviously, that's not always possible, and it is sort of a case-by-case basis. So when we're looking at whether receiving rent has waived the right, we're looking at, firstly, money needs to have been tendered and accepted as rent. That's just an issue of fact. Following which, we look at whether the right to forfeit has been waived. That's a question of law. So the final point that I'll raise on unequivocal acts is where proceedings are brought. So service of a claim form for possession, as Natalie said, is viewed as being the final election to determine the lease. So if a landlord brings a claim for forfeiture and then rent is accepted after, that's fine. But you do need to be a bit careful about bringing proceedings with multiple relief. As Natalie said, you might be sort of looking at which option is most beneficial, most commercial to your client. If you're thinking, for example, of bringing a claim for possession, including injunctive relief based on covenants and a lease, such as allowing a landlord to enter to inspect property, that may well, that side of it, the injunctive relief, may well amount to a waiver.
So do you think you shouldn't be doing both? You should be doing one or the other?
So where a claim is issued for possession and an injunction would normally be inconsistent with forfeiture, there's no unequivocal election provided that the injunction is pleaded in the alternative. So you need to be really clear that you're pleading the injunctive relief in the alternative on the basis that essentially the claim for the injunctive could always be abandoned before trial. If it's a standalone claim for performance of a covenant, then that's going to amount to a waiver by accepting the continuance of the lease. But it's okay to threaten injunctive relief. It has been seen that a threat to issue a claim for injunctive relief isn't a waiver where no Section 146 notice had yet been served, because no election at that point had been made between the two. Long acquiescence in repeated breaches of covenant may also amount to a waiver. And there's some case law, Kelsey and Dodd, which suggests that. Unfortunately, when it comes to these things, it is a little bit case by case basis, and it's a delicate area as to whether or not something has been an unequivocal act. But some of those examples mentioned are ones that have been put before the court before and decided. So the third ingredient, which I'll pop up on the screen now, is communication. So this unequivocal act needs to be communicated to the tenant. So, for example, where the waiver relied on is sending of a document, the waiver is not effective until the document is received. And you'll see on the screen the case that comes from. So David Blackstone and Burnetts. I briefly mention the categories of continuing breaches versus once and for all breaches. And this is an important distinction when it comes to the effect of forfeiture and the effect waiver has. So I will cover that very briefly now. Where it's a once and for all breach and there's a waiver, as it suggests in the name, the landlord loses the right to forfeit for that breach forever. So common examples on the slide are arrears of rent, assignment and subletting, failure to carry out repairs or works by a specified date, and alterations. Those are all examples of once and for all breaches. I will just caveat with arrears of rent, you lose the right to forfeit for that breach. But if there's a further breach, so for example, the next period of rent, then you can forfeit as it's classed as a new breach. Continuing breaches, different. The breach essentially arises afresh each day and will accordingly survive an act of waiver. Common examples that we see are failure to keep the demised premises in repair, failure to keep them insured in a certain manner, and use in a prohibited manner. Waiver of forfeiture is based on the landlord's election and only bars the remedy of forfeiture. So the right to damages is not going to be impacted by a waiver for forfeiture. So you can still, your right to damages remains intact.
Did you have any practical top tips for everyone who's listening on the question of waiver at this stage?
I suppose that's probably why people are here, right? They want to know practically what to do. So my main tips are, firstly, put a rent stop on tenants' rent to avoid inadvertent waiver if that's possible. If a landlord does receive rent, then try to return it as soon as possible. As I say, by bank transfer is best. If that's simply not an option, then potentially by cheque. I've had to advise on that area before. So that's a step that can be taken if you realise essentially money's been received when you've tried to stop it from being received. A lot of the landlords that we deal with have managing agents. So really the managing agents also need to be made aware of these issues so that they don't inadvertently waive. So this means managing agents need to be aware of what covenants are in the lease and knowing not to demand and accept rent following a breach of one of those covenants. And then I suppose finally links back to the last thing I said. Think carefully if you're bringing forfeiture proceeding or possession proceedings and injunctive relief. Just make sure that it's done clearly in the alternative. Otherwise, you're going to run into issues with waiver. So to end my little bit, I thought we could play a quick game to recap of what I hear is Channel 4's hot new game show, Waiver or No Waiver. So I'm going to put on the slide a table. There we go. And these are some scenarios that I've briefly spoken about today, except for the last one. So if you were listening, which I'm sure you all are, then you will be able to have a think about whether these scenarios constitute a waiver or a no waiver. So the first one, acceptance of rent because of a clerical error. That is a waiver. sometimes a bit surprisingly, given that, it might have been an error to get it in and you might have tried to stop it from being accepted. That can be a waiver.
Can I
Second,
do the next one? Can I do this one?
oh yeah, okay. Receiving
Sure.
rent without prejudice or under protest. Go on, Natalie.
Waiver.
You are correct. As we said before, simply saying that you're doing it without prejudice to your right to waive, right to forfeit, doesn't work. Thirdly, serving a notice to quit. Give you a moment to think about it. It's another waiver, so be a bit careful about that. But serving a Section 146 notice, slightly different category because it's no waiver. That is fine. Next scenario, we have landlord says to the bank, do not accept rent. I'm going to forfeit. Unfortunately, rent is received and the landlord notices that it's been received, no steps are taken to return it. Do we think that is a waiver or no waiver? It's a waiver because they didn't take any steps to try to rectify the situation. Again, sort of case by case basis, but as I say, if you receive it, try to send it back. Service of possession claim for forfeiture with injunctive relief in the alternative.
Well, I feel I should answer this one because I asked the question. You answered it for me. So,
Yeah, were you listening, Natalie?
was I listening? Yeah. No waiver.
Correct.
I was listening.
Good. I'm glad to hear it. Following on from that, threat to issue injunctive relief, but nothing's been done yet. No Section 146 has been served. That is no waiver. You are fine. And finally, an offer to buy the tenant's interest. That is a waiver because you're saying that it still exists. Okay, well, that's me done. And I'm going to hand over to Amber, who is going to talk a little bit about, well, if you've elected to forfeit, is that the end of the matter?
Yes, well, so often it's not the end of the matter, because you may at this point, as a landlord, face a claim for relief against forfeiture, or as a tenant, be seeking to get relief from forfeiture. So there is a difference in approach depending on whether the case relates to forfeiture for non-payment of rent or for breach of some other covenants. So that's you can get into a bit of a debate there about whether a particular sum has been reserved as rent. That might become an issue in relation to Section 146. Because if the breach is anything other than non-payment of rent, then the jurisdiction to grant relief is found in Section 146. But for non-payment of rent cases, you'll be looking at sections 138 and 139 of the County Courts Act 1984, or section 38 of the Senior Courts Act 1981, or inherent jurisdiction of the High Court. And that just depends on where the claim's being heard, and also whether the landlord is proceeding by action or relying on the right to re-enter, which Natalie talked about earlier. So starting off with breaches of covenant other than non-payment of rent. This could be a repairing covenant, a user covenant, or a covenant against alienation or subletting, for example. And in these cases, Section 146(2) of the Law of Property Act provides that where a lessor is proceeding to forfeit by action, i.e. proceedings or otherwise, then the lessee may apply for relief. The court has a wide discretion. It will have regard to the proceedings and the conduct of the parties, and also to all other circumstances as it thinks fit, and it can grant relief on such terms as it thinks fit.
Can I ask a quick question? Obviously, if you're a tenant facing the landlord trying to elect to their right to forfeit, that's obviously concerning. So when's the earliest that you can apply for relief?
So for the purposes of Section 146, a landlord actually begins proceeding to enforce their right as soon as they serve a Section 146 notice. So from that moment on, the tenant is entitled to apply for relief and doesn't have to wait either for the landlord to serve possession proceedings or to attempt re-entry. But on the other hand, there is a clock starts running, so it will be too late for the tenant to apply once the landlord has both obtained judgment for possession and actually recovered possession pursuant to the order, because at that point enforcement is complete. However, if the landlord has recovered possession by re-entry rather than pursuant to an order, then the right to relief to apply for relief continues. And just on the wording of Section 146 itself, the other point to bear in mind is that it's the lessee who's entitled to apply, and that means in the case of joint tenants, both joint tenants. So there is a 1931 case called Fairclough and Sons and Berliner, which says that the application of one isn't going to be enough. And that reflects the fact that if there's one joint tenant who doesn't want to have relief and carry on with the lease, then it wouldn't be fair to subject them to the onerous obligations of continuing the lease by granting relief. So the first question for the court in these cases is whether relief should be granted. And some of the most common considerations that the court will take into account here include, firstly, whether the breach was willful or deliberate. It does weigh against relief, but it's worth saying that even if a breach is willful and deliberate, there's no requirement for exceptional circumstances before relief can be granted. Secondly, the court will consider whether the damage that's been sustained by the landlord as a result of the breach is proportionate to the advantage they would gain if relief isn't granted. So would there be a disproportionate windfall to the landlord? And that may well be the central question. The court is reluctant to give the landlord a windfall by allowing them to forfeit for something which may be a relatively minor breach in proportion to the value of the reversion. Thirdly, does the breach consist of doing something without consent, but the landlord couldn't reasonably have withheld consent if that had been requested? So that's something to consider. For example, if there's been a subletting or some alterations for which the landlord couldn't reasonably have withheld consent. And then the court must also consider whether there should be any conditions applying to the relief if it's going to grant relief. So the general principle for conditions is that the landlord is entitled to be put in the position they would have been in, but for the forfeiture, but for the breach. Often, but not always, the tenant will be required to remedy or compensate the landlord for the breach and or undertake to fulfill its obligations in the future. And finally on this, and which is connected, where relief is granted, there is provision in section 146(3) for the landlord to recover reasonable costs and expenses incurred in reference to the breach. The lease itself might also contain an indemnity to this effect, and it's worth checking whether that's there. And generally, one of the terms of relief will be that the tenant pays the costs of the proceedings. And that's all part of the process of putting the landlord back into the position that they would have been in otherwise. However, when acting for a landlord particularly, it's worth considering that the court does retain its discretion as to costs, and landlords should be wary of pursuing forfeiture unreasonably or increasing the costs of an action by unreasonably opposing relief, because if they're found to have done so, then there may be some risk on costs. Turning then to the non-payment of rent cases, you can see on screen some of the relevant statutory provisions. Section 1392 applies in cases of re-entry in the county courts, and in the High Court, Section 38 applies in forfeiture proceedings, and the inherent jurisdiction is engaged in any other case, so for example in cases of re-entry. Whichever basis applies, essentially the same principles are relevant. There is a difference if Section 138 of the County Courts Act applies, which I'll come back to. So the relevant principles flow from the idea that a forfeiture clause is security for the landlord's right to receive rent. So in any case where the tenant pays up the rent and expenses, it would take something exceptional for the court not to grant relief. And it's important actually that the tenant can provide evidence of their ability to pay the arrears, because simply saying I'm willing to pay may not be enough for the court to grant relief without consideration of whether they can actually follow through on that.
On that, what if the tenant has a history, so persistently bad at paying, or is not only in arrears but also breaching other covenants in the lease? Will that impact what the court thinks?
Well, this is one of the things that people often find surprising, and I've had to advise clients in this sort of situation before, but it follows from what we've said about the court's understanding of its function, and the proviso being security for the rent, that even if the tenant has been historically bad at paying the rent, that won't be relevant for even in an extreme case where the landlord's previously had to bring several claims for unpaid rent. That doesn't discharge this assumption that if as long as the arrears are paid, relief will be granted. But what the court might draw the line at is where the tenant is sort of playing the system by waiting until the last possible moment to pay up. And so that might be a consideration. As for other breaches of covenant, again, I think landlords feels slightly hard done to, but in all but exceptional circumstances, the authorities do say that those should be ignored as well, where the forfeiture itself has been for non-payment of rent. By way of illustration, a tenant being convicted of an indecent assault committed on the premises wasn't exceptional enough. However, there are some cases where relief has been granted against forfeiture for non-payment of rent with a condition that other breaches are remedied. So it may be worth trying to either agree that if you're amenable to settling a claim which involves an application for relief, or seeking that condition from the court as part of the proceedings.
In some cases, well, probably actually many cases with the state of especially county courts at the moment, these disputes obviously can take months to resolve in court. Meanwhile, the landlord might be stuck with a property that's not generating any income. This is certainly situations that I have seen. Can they claim rent from the tenant for the period that the property is empty?
Yes, that's certainly something that can be a concern for landlords. And there is a helpful authority from last year, which says that a tenant can be ordered to pay rent from the period from re-entry to the date of relief being granted as a condition of getting relief. On the other hand, any benefit that's obtained by the landlord as a result of re-entry will need to be taken into account, because the court doesn't want to create a situation where the landlord is profiting from the re-entry. Finally, on the principles in these cases, that issue of how long things tend to take connects us to the question of delay. So, because this is an equitable jurisdiction, the tenant can't unreasonably delay making their application. In some circumstances, there's actually a hard 6-month limit. So that's if Section 139 of the County Courts Act applies, or Section 210 of the Common Law Procedure Act 1852. That's a hard limit, but otherwise that 6-month period will be taken as a guide for what's reasonable. But that's not to say that just because the application is made within 6 months, the tenant will be fine. It might be inequitable to grant relief, even if they've complied with that. For example, if the landlord has granted a new lease, particularly where the tenant's waited right till the last minute to make the application. But yeah, it's worth bearing in mind that that granting a new lease doesn't necessarily bar relief, so that can create a really difficult situation for landlords if they have very quickly granted a new lease after re-entry, for example. And finally, on non-payment of rent, in cases where the landlord has brought forfeiture proceedings, it's important to be aware that Section 138 of the County Courts Act provides the tenant with a route to what is a sort of automatic relief. So in cases where the lessee pays into court or to the landlord within more than 5 clear days before the hearing, then the action will automatically cease, and the tenant will hold the land without a new lease, so effectively get relief. Now we could spend a lot of time considering the position of subtenants and mortgagees in detail, but in the interest of time, I'll just say that Section 1464 makes provision which applies for breaches of all covenants, including rent. So this is a rare situation in which you can look to Section 146, even where rent's involved. And generally, the same sort of considerations apply as to whether to grant relief to a tenant as to a subtenant or a mortgagee. But the court will be slightly more cautious given the potential to force a relationship on a landlord which they haven't chosen for themselves.
So to round things off, what happens if relief is granted?
That is a good question. I've got two pictures here that sort of represent two of the phrases that I like to bear in mind. So the first is that relief has this sort of phoenix effect. The lease is retrospectively reinstated, along with any derivative interests, such as subleases. And then the second image, there's a case called Mount Cook Land Limited and Media Business Centre Limited, in which the court described the lease as having been in a shadowy state while forfeiture proceedings were ongoing. And I know Nat used the phrase the twilight period earlier, so that's something to bear in mind. In that case, where the landlord had discontinued its forfeiture claim, the court said that the lease simply returned to its full force and effect, and ceased to be in that shadowy state. So I think that brings us to the end of sort of tour of the topic of forfeiture, and I'll stop sharing my screen now.
All right, thank you very much. Well, I see we've only lost 3 people at the end. We will be in contact with those 3 people to work out what happened there. But well done everyone else for making it to the end. Unfortunately, we have used the full hour this time. So if you do have any questions, please do feel free to email us. If our email addresses weren't on the slides, mine was, you can find it online, or you can contact us on LinkedIn. The next junior program, we're having a little break for the summer. The next junior program is Olivia again. She's very busy. 9th of September, in person. There will be drinks. You should attend. The topic is restructuring and insolvency. So keep an eye out on LinkedIn and other social media where we'll advertise that. You may receive an email in your inbox, and we'd love to see you there. Otherwise, have a nice day, have a nice summer, and we'll see you all soon.